Okay, this is part B on legal entities. We're going to be talking about corporations. Before we do that, I do want to make sure that all of you are reading the cases that are posted. There's like one page, quick summary of the cases, and then it has a quick analysis. They're very important, especially this week. Each week, there are cases selected to highlight some of the major concepts that are being discussed. So be sure to read those. I try to incorporate some of them into the forms. I will incorporate some of them into the exam as well. Okay, corporations and LLCs. Remember from the last session we talked about there are three types of corporations. There's a regular corporation, or a C Corp it's called, a subchapter S, and nonprofit. Historically, they were started in Europe. I'm not really concerned with too much of that, other than the fact that originally the U.S. corporate charters were issued by state legislatures. If you wanted to form a corporation, you had to have a bill passed by the state legislature. That later got changed so that the states allowed their secretaries of states and follow a normal procedure so that corporations could be done very quickly and effectively. But this highlights the issue that corporations are state entities, not federal. They are all, every state has its own corporate code and its own laws on how to form corporations. Many of them are very, very similar because of the uniformity of the laws in the U.S., but it is dependent on each individual state. Okay, corporate managerial control. You all know that corporations have shareholders. The shareholders are the owners of the company. The owners will elect a board of directors. They're elected by the shareholders. The board of directors will hire the officers of the corporation, and the officers of the corporation will hire the employees. That means that shareholders cannot direct day-to-day activities. All they can do is vote on a board of directors. If they don't like what the officers are doing, they have to wait until the election comes up for a new board and vote in somebody else that'll make the changes. So the board of directors has the oversight, the strategic running of the company, while the officers run the day-to-day operations. A corporation has limited liability to all of its shareholders. That is one of the key factors. That's why it's so popular and has been around for hundreds of years. It means people can invest in a business, and the only thing they can lose is the amount of their investment. They are not liable for any of the activities of the corporation itself. There are certain exceptions, as there are in every concept in law, and under certain circumstances a court may pierce the corporate veil and attach personal liability. And that's when the corporation itself is not treating itself as a corporation. Look at Kinney Shoes v. Poland and find out why, and sometimes why a corporation is not going to protect the shareholders. Usually it's only one shareholder, and it's usually a ruse to attempt to get limited liability without really following the corporate requirements. One of the biggest tests is it adequately capitalized? In other words, if you start a corporation, put enough money in it to run it. Also, will you follow the normal corporate procedures that are required by a state? If you ignore the legal requirements for a corporation, don't expect the court not to do the same. Okay, double taxation. We've talked a lot about that. The corporation is taxed as a separate entity, which means that shareholders are subject to a double tax. Let's look at this example. A corporation earns $100,000. Corporation pays 30% taxes on it. So their net income after tax is $70,000. The individual gets a $70,000 dividend. Tax rate for the individual is 20, maybe 35%, depending on what Congress wants to do. But say it's 20%, so there's another $14,000 in taxes taken out of the original $100,000 corporate earnings. That means the net income to the individual is $56,000. That means that $46,000, or 46%, of the income was paid in taxes. What would have happened if that had not been a corporation, if it had been a partnership or a sole proprietorship? The legal entity earns $100,000. The individual was in the 20% tax bracket. They paid $20,000. Their net income after tax was $80,000 versus the $56,000 that the corporation ended up getting because of the double taxation. Okay, corporate formation. You have articles of incorporation. These are called a charter. This is filed with the Secretary of State, and it must be filed with the Secretary of State if it is going to give conclusive proof that the corporation is in existence. If you don't file it with the Secretary of State, then it will be treated as a general partnership with severe personal liability consequences. So you must follow the law in forming a corporation. It's not hard to do. It just happens to be something that has to be done. You can actually go on the Secretary of State website for Oklahoma and file a corporate articles and form a corporation in just a matter of a few minutes and a very low cost of a couple $100. Bylaws are adopted by the Board of Directors, and that tells the legal entity, the corporation, how it will function. These are the rights that the shareholders have. It talks about the internal rules that will govern it. The shareholders have the absolute right to amend the bylaws, and these do not have to be filed with the Secretary of State. That is just that they are part of the operating records of a corporation. Classification, there's profit and non-profit corporations. A non-profit corporation is a corporation formed in the state, just like a C corporation, but then it files for a non-profit, a non-tax status under the Internal Revenue Code, Section 501c3. Non-profit corporations are formed for charitable, education, religious, or scientific purposes. It is not taxed. We're going to be talking about that in the last week. So all you have to need to know now is a nonprofit corporation is formed by in the state as a regular corporation for nonprofit purposes and is not taxable either at the state or the federal level. You also have a subchapter S, or an S corp or a sub S corp. A sub S corp, again, it is a corporation formed by the state, but under the subchapter S section of the Internal Revenue Code, it changes the tax status. So it has to be a domestic corporation, has to have 100 or fewer shareholders. The shareholders must all be individuals, not corporations or partnerships or LLCs. You cannot nest different types of entities. Otherwise, it wouldn't be limited to fewer shareholders. It's non-tax residents, no non-U.S. resident shareholders, has only one class of stock, common stock, and it must be an active business, not a passive investment company. If somebody qualifies as a subchapter S corp, then that subchapter S corporation is taxed as a partnership. It is not taxed as a legal separate entity. The shareholders in that case have the tax liability passed to them, not to the corporation. So it's taxed like a partnership, but the liability protection for torts and contracts is the same as corporations. So the shareholders have no personal liability for the operation of the corporation, but it is not double taxed. So it's treated like a partnership. It passes through. We're going to be talking about a LLC, which is another form of a entity that gives personal protection to the members, but is taxed like a partnership. You'll want to know why a subchapter S versus an LLC might be preferred in one place or the other. The reason the subchapter S and the LLC corporations were formed was for small businesses. It was really to say that the double taxation was too burdensome, and so small businesses under 100 shareholders for sub S are able to get the tax benefits while still maintaining the liability protection of a corporation. Limited liability company are called LLCs. The owners are called members. They are not shareholders. Shareholders are for corporations. Members are for LLCs. A member of an LLC can have an unlimited number of members. They may be individuals, or they can be partnerships, or they can be corporations, or they can even be other LLCs. So you can nest this. Well, the reason you can't do that in a subchapter S is it's limited to 100 shareholders. If you have no membership limitations, then why not allow other types of legal entities to nest together to be members in an LLC? And there's no limitation on citizenship or residency. LLCs are the newest form of legal entity. They've been around 15, 20 years compared to several hundred years for corporations. they're becoming more and more prevalent all the time. The management of an LLC, it is member managed. It can be managed. The members can designate that they will all be managers. They can have outside management, or they can designate a specific member to be the managing member for the LLC. All depends on how the LLC is set up. Liability of an LLC, the capital investment is the only liability of the the members that are part of the LLC. Any third party must look to the LLC for its obligation. The tax liability is the same as a partnership. The LLC is not taxed. The tax liability passes on to the members and a proportionate share to their ownership in the LLC. No personal liabilities for companies' debts or obligations. A LLC is liable for any loss or damage that any of its agents do, just as a corporation is, but the members themselves are not personally liable. Fiduciary duties owed to an LLC. Members of an LLC have the same duty of loyalty as GPs and as officers in a corporation. They have a duty of loyalty. They may not usurp LLC's opportunities. They have a duty of good faith and fair dealing. They can make no non-disclosed profits, and they owe a duty by there's no fiduciary duty owed by a non-managing member. This means that if you have a LLC that is doing say they're buying real estate and renting, a member goes off and finds what would be a good deal, they have to present that to the LLC. They actually have to forego their own personal benefit for the benefit of the entity to which they owe a fiduciary duty. One of the highest levels of duty in business, and it becomes very important when we talk about agency. Okay, so why select an LLC? Well, why not select a subchapter S? Go back and review what are the requirements for a sub S versus an LLC and answer the question. No membership restrictions. LLCs are also very easy to form. Go on the Secretary of State website for Oklahoma. You'll see corporations, LLCs, and partnerships all listed up there. Can be done very quickly and very inexpensively. Easy to operate, and they allow the members to determine how the LLC will function managerially by the actual document itself. It'll identify who the managing members are. Okay. Each partner in a partnership is jointly and severally liable for the claims against the partnership. True or false? That's true. And that's even if the partnership agreement itself designates another partner as the managing partner. I'm talking about partnerships now, not LLCs. But the partnership liability, even if the partner violates the partnership agreement, the other partners will be held liable for those actions. Okay, that's all for the legal entities. We'll have one more video talking about agency. Thank you.